Hey guys, I'm Mike Abernathy, Be Ambitious. I'm here with Harvey Cohen. Harvey, please introduce yourself. Tell everybody a little bit about yourself.
Hey, my name's Harvey Cohen. I have a law firm in Florida. We're statewide. We're about 55 attorneys right now, and we represent homeowners, asset owners, boards, condominium associations for any type of insurance claim.
Thanks, Harvey. I really appreciate you taking the time out to join us today. They say you are the godfather of the AOB, the AOC. So let's see if we can help some people out today. So in your opinion, how important would you say it is for asset holder, multifamily property owner, or residential property owner to document their property before a storm?
That's a great question, and it's extremely important that you keep proper documentation of your properties. Especially, we deal with a lot of condominium associations or even shopping malls, apartment complexes. And sometimes what happens is a hurricane might occur. They go out, they have their own crew and kind of go out and do some minor repairs and so on, and they don't keep track of that. And it's hard for us to try to remember everything they did if it takes them a while before they retain an attorney. So it's good to keep pictures and documentations of the property before anything happens. And when I talk about documentation, I'm talking about keeping track of all repairs, all maintenance, have pictures of the outside, the inside. There are actually companies that will come by and do full inspections and write a report for you. They'll bring out the drones and drone your roofs and get really good footage so that if a storm happens, and that will help us with your claim to show the insurance company that the property was in proper repair before the storm.
What's the first thing that you would tell people to do in the event there's a storm, a hurricane, hailstorm, windstorm? What's the first thing a property owner should do?
Contact their insurance company and call in a claim. So you always want to open a claim right away. Some insurance companies have time limits. In Florida, there are different time limits for different types of claims. So it's very important that you call in your claim right away, even just to open the claim. Even if you don't know the extent of the damage, if they ask you, tell me everything that's wrong. You just want to tell them, listen, I'm calling this claim. We had a hurricane, a hailstorm, whatever it was. I have a lot of damage to my roof or my exteriors. Can you please send somebody out to come and investigate?
How important would you say for them to actually take the photographs, the video, to actually show what has happened right after?
That's extremely important, and you want to either do that or hire a professional that will come out and document the damage. And it's important that we see that right after the storm, because that is going to help us with proof when we go to file the claim or if we end up in court.
What would you say is something that a homeowner or property owner should not do after an event? What shouldn't they do?
Well, I'm an attorney, so I would say don't give a sworn statement or kind of an examination under oath without consulting an attorney. Obviously, the insurance company has, hundreds or thousands of lawyers that work for them. You deserve a lawyer that works for you. And so you want to consult with an attorney and find out what your rights are, what your obligations are, what information that they're allowed to get from you and what they're not. And so I would say the first thing to do after you called in the claim would be call an attorney and make sure you find one that specializes in this kind of stuff. For example, we've been doing hurricane claims for almost 20 years, and sometimes we'll go to a city that had a hurricane, and you'll see an attorney that has a big billboard that says hurricane lawyer. But if you look them up, last week they were doing family law. This week they're a hurricane lawyer. So my point with that is it's important that you find somebody that actually represents, people with insurance claims and that they can handle whatever size claim that you have. If you have a $50 million loss on a condominium association, you don't want to hire a family law guy or a personal injury attorney. You know, they might be great at what they do, but you want to hire somebody that can really handle your claim.
How do you read the insurance paperwork? There's so much going on. You get the paperwork, there's RCV, there's depreciation, there's actual cash value. How do you actually read the paperwork?
That's important too, and I think really that's a great question when we talk about being prepared for all of this. It's great to talk to your agent about what kind of coverage you have. And a couple of nuggets that I love to tell people is that you always want to make sure you have RCV, or replacement cost value, as opposed to ACV, which means actual cost value. RCV goes like this. If you have a roof and it costs $1 million to replace that roof, the insurance company is obligated to pay that fair, reasonable amount. If you have that same roof, but you have actual cost value, and the roof is 30 years old, and that particular roof had a 30-year life expectancy, so they get to depreciate it all of those years, and essentially after 30 years, you'll be owed zero, even though you've been paying your insurance premiums. That's one thing, but let me mention another thing that is very important. On a lot of large loss policies, we see a certain provision, and it's something to really, if you have a commercial property, whether it's a condominium or a shopping mall, apartment complex, whatever it is, it's important to talk to your agent about a specific provision that goes like this. If you have a dispute with your insurance company, you cannot sue them in the state of Florida. You have to go through a certain type of arbitration. And this arbitration provision requires that you go through the arbitration with New York using New York laws, and the people on your panel, the essentially the jury that's going to make a decision about your claim, has to be made up of 3 senior executives currently working for an insurance company. So you can imagine what kind of result you're going to get if that's the case.
So the policies, it seems like it's pretty in-depth. Do you guys review policies? Is that something attorneys do?
Yes, we definitely. We review policies, when we get involved. Some people ask me to review their policy in advance, but I like to just kind of give them this information, some other things to look out for when we review their policies. But really, they need to have their agent provide them with the right information. For example, I don't know what's going on. I can tell them about these provisions that we just talked about, but I don't know what's going on. Maybe it's a golf course that needs special coverage for the landscaping. Maybe it's a condominium association that has a big, beautiful fountain that might not be covered unless the agent knows about it. So it's that kind of thing. But that's the first thing that we do when we get involved with a case. The first thing that we do is we ask our client, please send over a copy of the policy so we can analyze it and help them understand what's in it, what's covered, what's not. But it's so important to make sure you have everything in place before anything happens, because once a storm occurs or a loss occurs, you're stuck with whatever policy you have. So we can't go back later and say, oh, you know what, I meant to get the RCV, but I only bought ACV. We're stuck with whatever we have.
So in the policies, there's exclusions. What is an exclusion, or what exclusions have you seen in policies?
Right. I mean, there are so many to list, and so that's one important thing to know too. You might have a water exclusion. They actually sell policies in Florida that exclude water losses. So I can't imagine that. That's the number one cause of loss in Florida. And they have, this is kind of funny, that they exclude water, but they include volcano damage. So you can imagine if you're in Florida, but you don't have water damage coverage, but you have volcano coverage, it's not very funny. So there's some exclusions for that. There could be exclusions for mold or so on. And those are valid reasons to deny your claim. If you don't have the proper coverage, or if your coverage is excluded in some way written in the policy, insurance companies can and will deny your claim.
What is ordinance and law, and have you seen exclusions in the policy for ordinance and law?
So ordinance and law goes like this. If there's a difference, let's say you have a 20-year-old roof and you need to put on a new roof and you have replacement cost value, like we talked about, if you have law and ordinance coverage, that means maybe your old roof was worth, $20,000, but if you build it up to the proper code, it's going to be $30,000. So for insurance policies, you don't get to get any freebies or any increases or any additional costs paid for, except for if it's required by law and ordinance. And so what that means is, a roofer can't come out and put on a roof built to the specs from 20 years ago. They have to abide by the current law. So that's why the insurance companies, they sell the law and ordinance coverage, which provides additional services. Another way I like to explain this is, for example, let's say you have a interior loss and you have, Formica countertops. They're going to rip those out. And you say, well, as long as they're ripping this out, let's put it back with marble. The Formica countertops cost $1,000 to replace. The marble costs $3,000. So the insurance company is not going to pay for marble countertops or an upgrade. They'll give you the money that they were supposed to give you for the Formica, but you have to come out of pocket for the other. And that's the difference between when you have a law and ordinance, for example, roofs or windows, that they will have to pay the additional money because of the new law and ordinance.
And some people that I run into, some of my clients, they say they have a managed repair program. What
Right.
exactly is that?
So some insurance companies sell policies that say if you have a claim, you don't get to choose your own contractor. We get to choose the contractor for you. Some it's just straight up that's going to happen every time. Some it's at their option, and they'll sometimes they'll let people, or sometimes they'll invoke their option to repair and force the homeowner or asset owner to use their vendors that they want you to use.
When an asset owner or a homeowner has a disagreement with the insurance company or the price or the scope of work,
Right.
What should they do?
Definitely hire an attorney. What we do, for example, like I said, what we do is we'll analyze the policy, summarize it for our clients. Our next step is to hire the right experts. So we bring in experts that will document everything, that estimate the damage and write up a full scope with pricing. Generally, we bring in engineers when needed, and it depends upon what we're looking for. So we might have one engineer that specializes in roofs. We might have another one that specializes in windows and things like that.
And what is appraisal? What can you tell everybody about appraisal? What is appraisal?
Okay, that's a good one. That's a alternative dispute resolution. So basically, an appraisal is not what you think about when you think about, oh, I need to get my car appraised. It's not like that. It's a process. So in instances where one side or the other invokes appraisal, the homeowner, asset owner, the plaintiff will hire their own appraiser. The insurance company hires their own appraiser, and those guys are supposed to come together and figure out what do they agree on. And if they agree on everything, they can just settle the claim themselves. It usually doesn't happen like that, and they might agree on 10 out of the 30 items, but then it will go to an umpire. And the umpire, it's kind of like the judge and jury, that they review all the documents and make a decision. In Florida, that's binding. Once they enter an order, that order is binding on both parties. However, some policies say that either side can invoke appraisal, or both sides have to agree to appraisal. So there are different policies and different provisions like that.
So what's the risk with appraisal then? So that sounds like a pretty good, sounds like, why do I need to get a lawyer involved?
Exactly.
Or
Well,
attorney, I should say.
yeah. Well, when we go through the appraisal, we've already done all of the back end work before it goes to appraisal. So we don't just bring in an appraiser and go, here you go, here's the property, see you later. No, we already have the entire claim prepared properly, like I said, with the other experts. and the engineering reports and everything else that we need to prove the claim to get it, through the appraisal process to the umpire in a way that they can understand and that they agree with our side.
And in the state of Florida, are attorneys' fees, are they paid?
Yeah, sometimes. So there's a law in Florida, it's called the fee shifting statute. And it, to paraphrase, it goes like this. If you are forced to hire an attorney to represent you with a dispute with your own insurance company and you win, the insurance company has to pay your reasonable attorney's fees and costs. So what that means is if you hire an attorney to represent you, many times if we go into litigation, they're responsible for a portion or all of your attorney's fees. It's not paid out as a percentage. It's paid out in a variety of other manners. How much time you have spent on the case. It actually gets deeper than that when if a judge has to answer the questions for us, then they'll want to know what experience do you have. So for example, somebody with 1 year will get a much lower rate than somebody with 10 years. And how much experience you have in this field. The same thing, maybe you're a 10-year lawyer, but you haven't done any property damage, as opposed to one of our attorneys with 10 years of experience in property damage.
What can you tell the people about the matching laws in the state of Florida? Let's say, for instance, a storm comes through, you have hail damage, you have 36 tiles, that were damaged, and they don't match anymore, or there's damage to the paint. One side is damaged, but then the back side's not damaged, but when we paint it, it doesn't match.
Right. So insurance companies love to just say, yes, there's damage, but it's repairable. So replace these few tiles and you're fine. But that's not how it works. So there has to be matching. All of your roof has to match each other. I've even had cases before where we were fighting with an insurance company and they said, oh, we found this company in California that will match these tiles exactly. So I said, okay, what's the company? And give me the address. We actually jumped on a plane and flew out there and went to the tile manufacturer with the tile and said, hey, we brought this. We didn't tell them we're attorneys, but we just said, look, can you guys match this for us? We have just a few tiles that need to be replaced. You know what they said? Nope, there's no way we can match this tile. We can't match it. They say, even if we use the code on the back or whatever it is, or the lot number that tells you the exact chemical composition, we still can't match it. It's not gonna match. So we were like, okay, thank you, and we ended up settling in that case.
All right. Why does an insurance company tell a property owner or business owner to get 3 bids?
So that's that's some kind of fiction that insurance companies come up with. There's no requirement for that. And a lot of times insurance companies love to say things like that, like get 3 bids, or for example, overhead and profit. They say, well, you didn't have 3 trades, but that's just made up by the insurance industry. And there's, whenever they tell us anything like that, the first thing I would say would be, just show me in my policy where it says I have to do that, right? You don't have to. The lowest bid on a project isn't the best bid. You want to find the best, highly qualified experts to do your work.
And that's what I was going to ask you. It seems, the lowest bid doesn't seem the best interest of the client.
Sure.
So how long in the state of Florida do you have to file a hurricane claim, and how long do you have to file a hail claim?
Okay. So in Florida, the statute of limitations for any contract is 5 years. So that means you have to file a lawsuit within 5 years. Any contract, so what's an insurance policy? That's a contract, right? So any claim has to be litigated, or the case has to be filed with court within 5 years. However, a few years ago, they changed the law to require homeowners and asset owners to file notice with their insurance company within 3 years for hurricane claims. So the statute goes like this. Essentially, you have 3 years to put your own insurance company on notice of a claim. 3 years from the date that the hurricane crossed land, and you have to either reopen, or supplement a claim in that shorter period of time. You can still litigate it after that for 2 more years. You can file a lawsuit, but you have to have already filed the claim with your insurance company before the 3 years.
3 years after the date of loss.
Yes, sir.
And if you sign a release, can you still file a lawsuit?
Okay, so that's a good.
What is a release?
Right, and that's a good question. Some people think, well, that our insurance company already paid me, so my case is closed. If I call them to say your case is closed, that's fine. We can reopen that, and generally that's what insurers should do. If they're paying out on a claim, they should pay out the money that they know that they owe, and that allow their clients to continue their investigation if there's more damage that comes along. However, if they sign a release, that's more of a legal document that says we agree that this is the last payment I will ever get, and it goes into a lot of details. My heirs and assigns and everybody in the whole wide world. Nobody can ever come back to the insurance company and claim any money on this amount of money that the insurance company is giving you. If you sign that, it's over. And you got to be careful too, because some insurance companies were actually putting that language on the back of a check. And so when they sent homeowners a check for $7,000 when the damage was $250,000, and they were signing the back of the check just to deposit it, thinking that they're just going to deposit this and continue working with their insurance company would say, nope, you signed a release. And the language was on the back of the check.
Man, that sounds horrible.
Yeah.
So what happens if you sign up with a public adjuster, or let's say even a contractor, and you want to get out of it? How do you get out of it?
Well, listen, a contract is a contract, and there's many, many different kinds. Most of the time, there will be some type of, for example, with contractors, they may have a liquidated damages clause that says, you can cancel this contract, and this isn't a penalty, but this is, the contractor says, look, we spent time, money, energy, effort. We worked on your case while we weren't out working on other cases. So let's agree that, for example, you'll pay us 20% if you cancel this. So they can cancel it and pay that liquidated damages fee. I don't know if public adjusters have the same kind of liquidated damages, but I think they would be entitled to payment for work that they've done, plus any costs that they've spent. I can tell you, I work with a lot of great public adjusters who send us cases for litigation, and I know when we've been involved with homeowners that want to, discharge their public adjuster, usually the public adjuster just says, okay, and gives them a release.
So in some instances, when you want to, if you hire a contractor and you have a contract, but they pull the permit, but they're not doing any work, what happens then?
Well, it still depends upon what the contract says. What did you sign with that contractor? If it has those kind of provisions in there that are legal in Florida, you're going to be stuck with those provisions.
Does the contractor have 30 days to start the work? How does that work? Is there a law that says that they have 30 days to start the work after the permit's pulled, and if they don't, they have to send a demand letter in? Is there something that would protect them if they're just not performing?
Well, protect who? The homeowner or the contractor?
Homeowner. Okay,
yeah, so I don't know the answer to that, but I do want to mention this is one thing, and maybe we could look this up later and I could give you guys some more information about it, but there's another law in Florida that goes, if you take a deposit from someone who's 65 or older, you can, if you don't start the work within 30 days, then they can come and arrest you, and I've seen them actually do that.
What can you tell us about mold claims?
Well, mold claims, that's another good question when we were talking about provisions and exclusions. So you want to make sure that your policy has proper mold coverage. You might have $10, $20, $30, $50,000 worth of mold coverage, and it depends upon what you think that you need for your own property. But I can tell you I've had claims where the policy limit is $50 million and the mold coverage is $15,000. So if those properties had a big loss and had mold and went to their insurance company and say, hey, we have $1 million worth of mold damage, the insurance company would say, yep, we agree 100%. Here's $15,000. Thank you.
Oh, wow.
So yeah, so it's important that you know what's in your policy and make it, match up. You don't want a $50 million policy with $15,000 worth of. Okay.
So there's a hurricane,
Right.
There's wind damage, you got water inside. How important is it to actually get the wet materials out of the house before the mold actually happens?
It's extremely important. So you need to call someone out right away. Like we were talking about before, you need to bring in a mitigation restoration company that will come in and dry out everything, tear out all the wet stuff, take anything that may cause future damage to the property. That all needs to be removed. But the other thing that is important is that you also need a roofer that will come in and do whatever emergency repairs, whether it's putting on tarps or shrink wrapping the property, whatever that property calls for. But because you need to stop that water from coming in so that it doesn't continuously get wet, even though the guys underneath are doing their job.
So in the policy, in the contract, is this actually something mitigating the property? Is that something that the homeowner has to do? Is that in the contract?
100%. So every insurance policy has a provision that you need to do whatever you can to mitigate damages to your property. What that means is you have to stop any problem from becoming worse. So that's the perfect example. Yes, it got wet, but let's stop it before mold grows everywhere. Or let's stop it before it keeps wicking up the walls and creating more problems.
What can you tell us about consequential physical damage? And I'm going to give you examples. I've had this happen hundreds of times. So we're doing a job, there's roof to wall, there's a stucco, we've got a tile roof, we've got to replace the flashing. The stucco gets damaged when we replace the flashing, so now we have to fix the stucco. But it was an event of actually doing what we were supposed to do. So what is consequential physical damage, and is that something that's covered?
So the answer is yes, it's covered, and it should be anticipated. So generally, and that's what we were talking about earlier, is when you bring out the right experts and estimators, when they look at the project, they'll say, listen, when we tear this out, guess what's going to happen? It's going to tear out that stucco. We're going to have to repair that stucco. Then we're going to have to repaint. So that means we're going to have to repaint the rest of the place or whatever they have to do. It's just like, for example, if you have a pipe leak in your house, they don't have to pay to fix that pipe, but they have to pay to, drill down and trench out your house to get to the broken pipe.
So what can you tell everybody about what is a proof loss?
That's a good one. So some insurance policies have a provision that says, upon our request, you must provide a sworn proof of loss. And that means they're asking you to swear that these damages that you're submitting they're accurate and they're caused by whatever the claim is. Some insurance policies are very tricky. And they go like this. You have to submit a sworn proof of loss within 60 days. They don't send you anything. They don't request it. They don't give you a document to fill out. They just have it buried on page 57 of the policy. And homeowners and property owners are bound by that provision.
So we have a big hurricane event, a big storm event, and we have to get money to the contractor to mitigate, because that's how do we expedite emergency funds in this situation?
So many times when we get involved with claims, we can provide the insurance company the mitigation bills and so on to the insurance company and ask for a preliminary payment to make sure that those things are covered. A lot of times insurance companies will pay that, or will give us, maybe we have a $7 million claim and they go, well, we don't think it's 7, we think it's more around 1. So they'll give us 1 right now, and that, to cover the emergency roofing repairs and emergency services on the interior of the building.
What percentage of insurance claims would you say are underpaid when the business owner gets their first check, the adjuster comes out to the property, or homeowner? What's the percentage you would say that you've seen that are underpaid on that first estimate?
I can't even make a guess about what that is. I can tell you that when we have claims, probably, if not 100% close to that, where the insurance company paid a certain amount, they owed much more than that. And they estimated it low and they paid it low, and we were able to recover the true value of the claim.
So just to wrap this thing up, I just want to thank you for coming out, Harvey.
Thank you.
If you could just tell everybody how to get a hold of you and how they can contact your firm.
That sounds great. So everyone can get a hold of me. The number for my firm is 407-478-4878. You can email me directly at hcohen@itsaboutjustice.law. You can feel free to call or email me anytime. We have about 55 attorneys right now, and we're growing, and we're really here to help people and answer their questions. Whether or not we can help you with something, we're here to whether or not we can answer your question, we're happy to help.